to go.
All right. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of inherited property, clearing title, deferred property taxes, and other probate concerns. And I know that's a long title. My name is Nia Murray. I am the Programs Coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included, we have the City of Houston's Department of Neighborhoods. Along with our presenting partners for this month, we have the Harris Central Appraisal District. And joining us, we have Ms. Mabel Menifee. Also, our presenting partner with the Texas Legal Services Center, we have Ms. Lisa Nelson. And on behalf of the Harris County Tax Assessor Collector's Office, we have Ms. Shay Pinkowski, who will be giving our presentation for today. But also included in the partnership, we also have Houston Volunteer Lawyers, the Harris County Attorney's Office, and the Earl Carl Institute. And together we make up A Month of Service. And just to kind of give you a quick little background, A Month of Service is the collaboration of all of our organizations. We come together on a monthly basis and offer every other bi-monthly basis now, to offer a variety of resources and information to the communities that we all serve, relative to asset building, asset protection, the maintaining of generational wealth, and community empowerment. We know that there are a lot of underserved communities that are out there that don't have access to a lot of information or resources, don't know where to go when they have particular questions or particular issues, and a lot of legal concerns. So we decided to collaborate several years ago in an effort to create a larger impact and to reach more people and to get as much accurate and up-to-date information out there as we possibly could. We know that there's a lot of misinformation out there. There's an abundance of all kinds of information from all kinds of resources that are out there. And we want to make sure that people do get the most accurate and up-to-date information as it relates to the state of Texas. We know that a lot of folks, get a lot of information off of, social media, the TikTok experts that tell you about everything under the sun. But it may not necessarily be relative to the state of Texas. So we want to make sure that you guys get a really good understanding of how clearing title for inherited property actually works here in the state of Texas. We want you to get all the information that you need when there's somebody that may have had deferred property taxes on their property, and what actually happens when someone passes away. What is that probate process like? Addressing those concerns for you. So this is your opportunity to ask questions of the experts that are in those fields. We want to again make sure that you do have this opportunity to ask those questions. However, we do ask that you try to keep your questions to be as general as you possibly can, so that you don't divulge any personal detail information, as well as kind of getting that information out there for everybody to have access to. We are on a public setting. We are on a public platform. We do record the session. We also broadcast live on our social media channels. So we want to try to protect your privacy as best as we possibly can. So do keep that in mind. In addition to that, when you ask certain questions, especially as they are legal in nature, there's so much more information and nuances that we need more information about before your question can be addressed. So we ask that we encourage you to reach out to our legal service partners for more one-on-one or personal information as it relates to your particular situation. But do feel free to type your question into the chat. If you are joining us on our social media channels, I am monitoring those as well. Feel free to type that question into the comment section. I know that there were a few questions that were emailed in advance when you registered. So I'll go over those if they are not addressed during the presentation as well. But you do have the opportunity at the end to unmute yourself and ask your questions directly if you don't want to put your question into the chat. So you do have that option. So we want to welcome everybody and thank you all for joining us this afternoon. Um, we've been, like I said, we've been doing this for quite a while, since 2017, 2018. We've been doing these presentations. We used to be out in the community, and we're looking forward to trying to slowly get back out there, at least on a hybrid basis, where we can kind of be in the community and still offer this presentation on Zoom. So we'll keep you posted as we get those things planned. So without further ado, there's going to be a lot of information covered here today. By no means do we expect you to be the legal experts, um, by the time this whole thing is over with. But we do, like I said, record this session as well as broadcast live. So you do have the opportunity to go back and review what was being said. Any documents or resources that are mentioned throughout the presentation, I will be sending you copies of those templates and forms and documents and links and everything so that you'll be able to have access to all of that as well. So with that being said, I think that's about it. Oh, most important thing, information that does get presented here today is for educational purposes only. It is not to be considered legal advice. But again, we do encourage you to reach out to our legal service partners for more one-on-one questions to be addressed. So without further ado, we're going to go ahead and get started. Ms. Mabel and Shea will have you guys introduce first, and then Ms. Lisa, you can introduce yourself, and then we can get right on into your presentation. So Ms. Mabel.
All right. Good afternoon, everyone. Thank you all for joining us. And thank you, Nia. My name is Mabel Menifee, and I'm with the Harris Central Appraisal District. And I am a part of this conversation today because I have the opportunity. I'm going to try to fill in some of the blanks as it relates to clearing title on inherited property as it relates to property taxes and exemptions. So I will be following Lisa to try to bringing up the back there for Lisa on those issues. So thank you again, as Dia said, for joining us, and I'll see you in a bit.
All right, Shea, did we?
All right. I don't think I figured out my camera, but I at the very least can be heard now, which is good. So good morning, everyone, or afternoon now. My name is Shay Pinkowski, and I'm here with the Office of Annette Ramirez with the Harris County Tax Assessor Collector's Office. And I, too, will be here shortly to be able to answer some questions and give a little presentation about how that process goes. As Ms. Mia said, please keep all of your questions kind of general as best we can. And if you need further information, I will have contact information up at the end so that you can ask your more specific questions to one of our representatives directly as opposed to on a live platform. But I'm very happy to be here, very excited to be able to speak with you all, and I look forward to it.
Okay. All right, Ms. Lisa. And I know a couple of you are probably still wondering why we have the tax office and HCAT and stuff here, but there are different exemptions that you can claim on inherited property. And again, if there are deferred property taxes once someone actually passes away, how does that relate to the actual inherited property? And we're going to tie all of that stuff in together. So so just stay tuned for that information. So go ahead, Ms. Lisa.
Thank you so much. Good afternoon, everybody, and thank you for joining us today. I'm here to discuss, this is sort of a follow-up to the Create Your Own Estate Plan and why you need an estate plan, as I show you how those documents get used once they're needed, as well as discuss how to clear title to property that you may have inherited. So this presentation is clearing title and other probate concerns, focusing.
It didn't share. We don't see it.
Oh, thank you. Okay, it's, how many years have we been doing this and we still run into technical issues?
Always.
Or if I may, while Lisa's doing that, interject. I do also have with me my colleague from HCAT, Donna Pensick, who can answer any exemptions related questions in the chat, or we can always go back and answer those later. But I did want to make sure you knew that we have one of our content experts working alongside me today. So
Thank you. And I will be reviewing the chat once I finish my presentation.
Swap view, Miss Lisa.
Oh, it was exactly the same way. Okay, is it
There you
correct
go.
now?
Yes, ma'am.
Thank you so much. Okay, so today I'm going to talk about an overview of the probate process as well as how to clear title to any heirship property that you may have and how to transfer property to your heirs in the future. And then I will pass it on to Mabel and Shay to talk about property tax issues because whenever we're talking about real estate in Texas, we have to talk about our property taxes. I'm with Texas Legal Services Center. We've been around since 1981, and we're a statewide nonprofit that provides advice, advocacy, representation, and education to underserved people across the state. And our work touches every aspect of civil law. We've got a veterans program, we have a handful of family law programs, custody issues, and CPS, as well as some to help crime victims. And our mission is to ensure equal justice for all Texans. So I'm a staff attorney. I'm on the Texas Law Help team, which, if you don't know the website, texaslawhelp.org, will cover any legal questions you have about civil law in Texas. We have thousands of articles and forms that you can use if you need to represent yourself in a legal case. So I'm going to talk first about probate. Hopefully y'all have been to the great presentations about estate plans. Here's what happens when you need to put those estate plans into use. So to start with some vocabulary, a decedent is a person who passed away. If they are known as testate, it's a person who passed with a valid will. Intestate is someone who died without a legally valid will. Now, that's a little bit more complex because if someone has a will, it doesn't necessarily mean that the will is valid. There are plenty of people that get things off the internet or write it up themselves, and those wills may not be compliant with Texas laws. So a testator is the person who signed the will, and a will is a legal document which states how the testator's property is to be divided at death. Estate is the property, both real and personal, owned by the person who passed at the time that they died. Probate is the general term for the court process, whether or not someone died with a will. However, the legal process is known as probate when someone applies to become the executor of a will. So I try to combine these as much as possible, but if someone passed with a legally valid will, the attorney files what is known as an application for probate. If they did not have a valid will, it's an application for administration. Now, either way, someone is appointed the personal representative of an estate. If there was a will, that person is called an executor. If there was no will, the person is called an administrator. And anyway, that's the person who's responsible for wrapping up the person's affairs and distributing the assets to the beneficiaries. And beneficiary or heir is a person who inherits through a will or by law. Usually, if there's a will, they're referred to as beneficiaries, and heir is the legal term.
Miss Lisa,
Yes,
someone
ma'am.
asked about the volume. Can everybody hear okay, or is it a little bit low for you guys as well? Everybody can kind of give me a thumbs up or yes or no, or
I'm
tell
taking
me
a
I
what
hear
look
you
just
at
all
fine.
think.
my volume is low on my computer, so I'll turn that up. Thank you. Hopefully this is better. Let's see, where was I?
Okay.
Is that better?
Yes, I'm getting thumbs, so yes.
Okay, great. Thank you. Thanks for letting
Swap
me
swap your view back.
know. Thank you. There we go.
Okay. Yes.
So here's some common mistakes that people aren't aware of. All of those people on social media or at the hairdressers or in your neighborhood that seem to be experts may not always know. So, for example, Powers of attorney are only valid while someone is living. Once someone passes, powers of attorney are absolutely void. So if you are a person's financial power of attorney, you have absolutely no power once that person has passed. Everybody thinks because Texas is a community property state that the surviving spouse gets everything. That is absolutely not true. A surviving spouse does have a right to live in the family home until they pass away. But if the property, if that family home was owned as separate property, perhaps the deceased person purchased it before they got married, the surviving spouse only has a right to 50% of it. Any children have a right to the other 50%. And if you select an executor in a will, they have to be over the age of 18, and it's best that they live in the state of Texas. It's always best to have an attorney prepare your will. Um, there are times when you can do it yourself, but I can tell you how many times someone thought they were smarter than an attorney or were worried that it would cost too much, and their family ends up spending thousands of dollars on attorney fees and court fees because the will is not compliant with Texas law. Um, it's forms downloaded from places like LegalZoom are not necessarily valid and compliant with Texas law. And our website, texaslawhelp.org, does have forms that have been approved by the Texas Supreme Court. Those forms can be used if you do not have an attorney. It's important for spouses to have separate wills. There are times when I've seen wills where one spouse wrote everything out and then both of them signed it. That may not be legally valid. However, you can individually handwrite your own wills. We have instructions on our website. It's called a holographic will. And if it's done according to those instructions, it can be legally valid. It's really important to let your loved ones know where your will is. Keep it in a safe place, but let at least the person who's appointed as the executor know where it is. And one thing that also is critical is to store your original will in a safe place that someone knows about it. If they can't find the original will, Texas law presumes that that will has been revoked. They think that if there's only copies available, they think you tore that original up because you changed your mind about something. And it's really important to know if you don't have a legally valid will, the law determines who will inherit your property. So it may not go to who you intend to get your property. If you cannot find a will, your attorney can file an application for administration. I will go into this more in detail in a few minutes, but you either file for dependent or independent administration, depending on the circumstances. Extremely limited cases, you're able to file a small estate affidavit. It's really important to talk with an attorney because they can help, once they have an understanding about what your goals are and what needs to happen with the property, they can determine the best way to proceed. We get this question all the time, and I know a lot of people who work in the courts do as well. You absolutely have to have an attorney to probate a will or to represent an estate that does not, that where the person did not leave a valid will. And this is a typo. I need to fix this new slide. Excuse me. In most probate cases, you are not only representing yourself, you're representing the interest of heirs, creditors, and the estate. There is only one exception. If you are the only heir to an estate, if you are the surviving spouse and there are no children, no other heirs, you may be able to represent yourself. Probate assets are property that passes through a will. That could be your house, any other property that you own. It also includes your real property, your personal property, such as household items, furniture, clothes, your car, your jewelry, etc. In Texas, we also have non-probate assets. These do not pass under a will. They pass in accordance with the terms of a contract. Common examples are any life insurance policies, any retirement plans, and payable on death accounts. If you learn nothing else today, please know that if you have payable and death beneficiaries on all your financial accounts and you have a transfer on death deed for your home, your family may not need to probate the will. They may not have to go to court, and the process will go much more quickly. You always want to have a will just in case there's something that you forgot to leave a beneficiary on. But if you make sure that you have payable on death beneficiaries, a transfer on death beneficiaries, the process will go much less expensively and much more quickly. So once someone needs to go to probate court, you have an attorney, and the attorney begins the process by filing an application. After 10 days, the attorney can schedule the hearing. This does not mean you will go to court that quickly. In Harris County, it could be 6 months to a year before you actually get your day in court. The issue is that even though we have 5 probate courts, the courts are just that busy, and it can take time to get that scheduled. It's usually a very short hearing. The judge will listen to the person who's filed to be the personal representative and possibly some other witnesses, and the judge will grant an application either to probate a will or an application for administration. And the personal representative will receive letters. They're called letters testamentary if there's a will, or letters of administration if not. Those letters are your official permission slip from the court to handle the affairs. You will take those letters along with the death certificate as well as a tax ID number and go to the bank where the person who passed had a bank account, and you will withdraw that money and open a separate bank account for the estate. The personal representative gathers all the other assets as well. The attorney notifies any creditors, so anybody that the deceased person may have owed money to. It is not the personal representative responsibility to pay those bills. There's a very strict process that the creditors have to go through where they have to file a claim with the court, and it has to be filed exactly the way the law requires. And then the final step, if this is an independent administration, is that the attorney, with the help of the personal representative, they prepare and file an inventory. That's a list of all the property that the person had when they passed. If you can get an independent administration or probate a will, it's the easiest procedure if the will is valid and no one files a contest against that will. You're in front of the judge for just a couple of minutes where you go through and show the judge that that is the last will and that you're qualified to be the representative. As I said, the judge will admit the will to probate or appoint you as an administrator. The attorney then notifies the beneficiaries and the creditors, and the inventory or an affidavit is filed. You can only use an application for independent administration if all heirs agree, and they have to file waivers with the court agreeing that they agree that that person should be in charge of the estate. It's usually less than about 15 minutes to go in front of the judge. The judge admits the person to be the administrator and goes through that same process. Dependent administrations, on the other hand, require strict court supervision. If the heirs do not agree, or there is a minor child as one of the heirs, you have to file an application for dependent administration. It is extremely time-consuming and costly. For instance, if someone passes without a will, and I had a situation where someone had a will that she got off the internet, and it wasn't even close to being legal in Texas. She had 3 adult daughters. One of the daughters wanted to be difficult and said, "I'm not going to agree to an independent administration." We had to have every single thing approved by the court. If there is a house that's involved, you have to have the court approved to have the grass cut. You have to have the judge approved to pay the electric bills. Everything has to go through the court, and that gets extremely expensive. Also, the personal representative of a dependent estate has to post a bond. It's usually 10% of the value of the estate. There is one situation where this can be good. If someone passed with a significant amount of debt, a dependent administration can help protect the estate from those claims. If someone passes without a will, the attorney also has to file an application for determination of heirship. You have to prove to the judge that you have not left off anyone who is entitled to be an heir of that estate. So what the judge does is they appoint a neutral party. They appoint an attorney to serve as the attorney ad litem who investigates the family history. They make sure that nobody's been left off. So what the ad litem does, they speak with the person who filed the application to be the administrator. They also speak with two people who knew the family well, but do not legally inherit. The prove-up hearing is between 15 minutes and maybe 20 minutes because the judge needs to speak with the attorney ad litem who discusses all they found out about the family, plus those two witnesses. And then the judge signs an order that lists everybody who is entitled to inherit from the estate and what their share is in the estate. You can also probate a will as a muniment of title. This is the one procedure that can be used more than 4 years after a date of death. If the only reason you need to probate the will is to transfer a house to the person named in the will to inherit it, is that you can probate as a muniment of title. You have to prove that there's a very good reason why you didn't file on time. The best example I saw, this was not my client, I just happened to be in court at the same time, was a woman whose husband had passed, and she didn't know he had a will. She couldn't find it anywhere. Well, she decided to sell their house, and while they were packing up things, she found a will. So she had to go to court to have the will probated as muniment of title. What happens at that point is you file the judge's order with the real property records, and that way there's a clear title from the person who passed to the person who was named in the will. And there is some extremely new law as of last year that this may be one time when you can file without an attorney. If, for example, if you were married and your spouse passes away, and the only thing you need to do is transfer that house to the surviving spouse, you may be able to do that without an attorney if nobody else is named in the will. A lot of people will go to the court and say, my mother passed away, she didn't have a will, I don't have an attorney, what can I do? They will tell you you can file a small estate affidavit. That is not necessarily true. It can only be used to transfer real property if it's a surviving spouse or a child under the 18. You cannot use a small estate affidavit to transfer a home to an adult child, even if the adult child was living in the house. Everybody, again, has to agree. So all the heirs have to sign the small estate affidavit, along with two disinterested witnesses. The disinterested witnesses knew the deceased person well, but they cannot legally inherit. You cannot use this process if they had left a will. You also cannot use this process if the value of the estate is, the value of the estate has to be greater than the debts of the estate. So say someone passed with an estate of $20,000, but they had $35,000 in debt. The judge will not approve a small estate affidavit. Additionally, the homestead does not count as the assets. So the estate, excluding that home, must be less than $75,000. Anytime we talk about wills, probate, people bring up trusts. Trusts have the best promotion of anything I've ever seen on social media and also just out on the street. A trust is a document that, like a will, states how a person's property is to be distributed at death. It can be used to transfer both real and personal property. Trusts are a very expensive stack of paper if nobody has transferred the property to the trust. Because they're a very complicated process, it is extremely expensive to have an attorney prepare your trust. If the attorney is doing their job right, they will not only write the trust, they have someone on staff who makes sure they do a spreadsheet of every piece of property, every bank account, everything you own, and go through the process to make sure that everything has been correctly transferred. I will never recommend creating a trust off something you get online because it is very easy to mess up the transfers. For example, if you don't use the correct language when you transfer your home from the homeowner to the trust, you will lose any property deductions that you receive or will be eligible for in the future. A great reason to have a trust, on the other hand, would be to protect assets to qualify for Medicaid. It's also good if you have heirs that are not trustworthy and you think that they're not going to be able to manage whatever they would inherit. Trusts do allow you to have control after your death. So, in situations where someone has an irresponsible family member, this is a way to protect them from themselves. And you do not have to go to probate court if everything is correctly owned by a trust. That being said, in some states, probate is extremely expensive. In Texas, if you have a valid will and nobody fights, probate court is not that expensive and it's relatively, besides the time that can happen, it's relatively painless. So let's move on to clearing title to inherited homes. A lot of people think that if there's a home that's been in the family for generations, it's a family home. You don't need to do anything to keep it in the family. However, if you may not have clear title, a lot of people think that everything is fine with their home. It's the family home. It was owned by an ancestor. But if they never went through a probate process or filed an affidavit of heirship, and then we have a hurricane or a winter storm or a windstorm, and they lose their roof, they apply for disaster assistance and they don't qualify because the title isn't clear. Additionally, you are not eligible for property tax exemptions or deferrals if you're not the owner of record. A clear title means that no one else has a financial interest in your property. It is a way to prove that there's no question of ownership and the ownership history is clear. Someone can go to the deed records of Harris County, Fort Bend County, Galveston County, and they can look through the records and see a clear chain of the home being transferred between each owner. If the property isn't legally transferred or deeded to the subsequent owner, the title becomes what is known as cloudy. This happens if someone dies without a will or the family doesn't manage the estate. There is a difference between titles and deeds. Title is not a piece of paper. Title is a legal right to the property. The deed is the actual piece of paper that conveys that legal right to the property. So real estate title is not a document. It's the strength of your ownership claim. Having clear title means that there's no unexpected claims on your property. And a deed is that actual piece of paper that transfers the ownership. So again, when I was at Earl Carl Institute, we had issues all the time where people found out that they didn't qualify for any type of rebuilding assistance from the state. They didn't qualify for property tax relief. You can't get home improvements or other types of loans. It's really important to go through the probate process because if you don't do that, along with not having clear title to the property, you may not be able to access any of their financial accounts. So there are a few ways to transfer title through the court system. If the homeowner died within 4 years, you file an application for probate or administration. And if there's a surviving spouse and no will, that surviving spouse can file a small estate affidavit. If it's been more than 4 years and you have a very good reason that you didn't probate the will, you can file an application to probate as muniment of title. All heirs do have to agree to this if there's more than one heir in the will. If you meet the requirements, there's also something known as a petition for adverse possession. So, as I said, if your loved one passed away recently, you can go through the regular probate courts. If you're probating a will, the judge determines whether the decedent left a legally valid will. If they did not leave a will or the will was not compliant with Texas law, you can file an application for administration. And as I said, in extremely limited circumstances, you can file a small estate affidavit. If it's been more than 4 years, you can file an application as muniment of title. There has to have been a legally valid will. All heirs have to agree to probate the will. And you have to prove that you had a really good reason. If there's only one beneficiary, you may be able to do this without an attorney. And what happens is the judge admits the will to probate, so they sign an order, and then you or your attorney would record a certified copy of the order with the will and the property records, and then you would have clear title. The person named in the will has clear title to the property. Small estate affidavit. So many people file these and the judge is not able to sign them and you're out $400. So it's really important to know when you can use this. You can file a small estate affidavit if there was no legally valid will. All heirs have to agree and sign the small estate affidavit. Can only be used to transfer a home to surviving spouse or minor child. And it also has to be signed by two disinterested witnesses. This is the one probate procedure where you do not have to appear in court. If all the elements of the law are met, the judge signs an order. You can then also use that order not only to transfer title to your house, you can use that order to transfer bank accounts. So I have circumstances where the only thing that the person owned was a bank account. You can use the small estate affidavit to transfer money where you would take that to the bank and be able to get access those funds. And another situation, there is adverse possession. Everybody has heard a version of this. This is a legal principle that allows someone to obtain ownership of a property based on continuous occupation without permission for a specified length of time. One of the real common ways of using this is there's a vacant lot next to your house and you've always kept that lot clean. Your grandkids play on that property. Everybody knows that that's where you garden and that's where everybody plays. Or I've had circumstances where the original deed has a mistake on it, but that family has lived in that house, and you can prove I've always gotten mail there. Everybody knows that I live there. This is known as my house, even though I don't have legal title. You cannot use adverse possession if you have permission from your family members to reside there. You can only use it if you do not have any type of permission to reside there. There's different lengths of time depending on various circumstances, but it's usually around 15 years. You can also clear title without going through the court system in certain circumstances. You can use an affidavit of heirship and you don't need an attorney. Our website, Texas Law Help, has detailed instructions and the form you need to use. And an affidavit of heirship is a legal document that gives property to the heirs of a deceased person. It may be needed if the homeowner did not have a will or if you did not probate that will within 4 years. So if it's, you don't necessarily have to go through the muniment of title. You may be able to just transfer the house through an affidavit of heirship and you could attach the will to it. So the affidavit of heirship cannot be signed by the person who is legally entitled to the home. It has to be signed by people who knew the deceased family's history well and can testify that, yes, this is the family who is entitled to own the home. It's critical that you include the full legal description of that home. You cannot use the description that's listed on the property tax bill. You need to get a copy of the deed and use that description. If you can't find the deed, you can get a copy from the county clerk in the county where the house is located. You also have to file the affidavit of heirship in the county where the property is located. You will have to pay a filing fee. It is much less than what you pay going through the probate court. It's usually between about $35 and $50. There's a certain amount that you pay per page. A lot of people get confused because we use the term affidavit so many different times. A small estate affidavit is a court process. You don't have to appear in court, but you file that in court to transfer real property to a surviving spouse or minor child. Or as I said, you can use it to transfer things such as bank accounts. Affidavit of heirship is the best way to transfer a home to a surviving spouse, adult children, or other transferees, such as nieces, nephews, cousins. And you can use the affidavit of heirship instead of going through probate if that's the only thing you need to transfer. Every time I help people get clear title, I say, let's please clear this up so your family doesn't have to do the same thing. So the best way to do that, and Miss Nia can talk about this at the end, there is going to be a transfer on death clinic next month. A transfer on death deed is a very simple and inexpensive way for a homeowner to transfer home or any other real estate to someone upon the death. Transfer on death deed does not affect your rights during your lifetime. You can still sell the property, use it as collateral for a loan. You're still eligible for any property tax exemptions. Additionally, the beneficiary doesn't have any rights until the owner passes. The owner also can change beneficiaries or transfer or cancel the deed entirely. Again, the deed has to be filed before you pass away in the county where the real property is located. So don't prepare a transfer on death deed and have it sit in that safe place with your will. It absolutely has to be recorded in the deed records. A lot of people talk about ladybirds, which are also known as enhanced life estate deeds. I have a slide coming up that explains the differences between the ladybird and the Todd. The main difference is if the homeowner is incapacitated, say they have dementia, their power of attorney can sign a ladybird deed to transfer the home. Ladybird deeds are accepted in 5 states, including Texas, and like the Todd, it avoids probate and Medicaid estate recovery. Medicaid estate recovery is a process where Medicaid can be reimbursed for any expenses that they paid for you in advance. It's pretty typical that people use Medicaid to pay for nursing homes. And if you transfer your house through a will, Medicaid can enter the probate court and request that they get reimbursed for the money they spent on your nursing home. So if you transfer your home through a Todd or a Ladybird deed, it does not go through probate and Medicaid will not seek reimbursement. I'm not going to go through all of this. You'll get a copy of the presentation later. But these are the differences between the transfer on death deed and the Ladybird deed. In general, the transfer on death deed is a better process. It's actually governed by the law. Ladybird deed is not. And the transfer on death deed allows you to have alternate beneficiaries. It also gives you a much clearer title than a Ladybird does. So transfer on death deeds, we have a toolkit on our website. This is the front page of it. We provide you with detailed instructions and the form that you need to use. Like the affidavit of heirship, it is critical to have the legal description from a deed and not from your property taxes. And again, it protects your property from Medicaid estate recovery. We have a wealth of resources in Harris County. There is the website I work on, Texas Law Help. We also have attorneys available to speak through chat from 10 to 2 Mondays through Thursdays. Our office also has a program called the Hotline for Texans. It can help with Medicaid applications as well as estate planning if you are a Texan who is over 60 or on Medicaid. Earl Carl Property Preservation is through Thurgood Marshall Law School at Texas Southern. They help people with any issues having to do with protecting or maintaining their property. Lone Star Legal Aid helps with any civil law. They're a fabulous program that serves all of East Texas. Houston Volunteer Lawyers is another place where you can get pro bono assistance. Legal Line is a program through the Houston Bar Association where you can ask an attorney for free about your legal issues. And Houston Lawyer Referral Service can provide you referrals to attorneys who have been vetted. They also have a list of attorneys who charge lower rates. Thank you so much for your time. I will stick around and be able to assist after everyone's done.
And all of those resources or those links to those various resources will be included on the email that I send out to everyone too. So if you didn't write them all down, don't worry, you will get those. So next we're going to have Miss Mabel with the Harris Central Appraisal District. Okay. And I said there's quite a few questions in the chat for you, so we'll get to those.
I will do quick answers, but we will discuss all of them afterwards to make sure that everyone gets this information.
Okay, Miss Mabel.
Folks. Now, there we go. I think you can all see my slides now.
Yes, ma'am.
Okay, perfect. Good afternoon once again, everyone. And again, my name is Mabel. And I am also joined on the call by my colleague, Donna Pensick, who will be answering questions in the chat. And she may even be answering some of the questions on audio once we finish with the presentation. So I'm going to go ahead and get started. Well, the reason I'm here is because there are some things that are related to taxes and property tax exemptions and the like that you part of the process that you need to keep in mind when you're dealing with clearing title and assuming heirship of property inheritance. And so I want to go over some of those just to kind of help you understand how those fit into that process. So so we will get started. All right, I want to talk, as I said, a little bit about exemptions and ownership. Just a quick explanation about what Harris Central Appraisal District is and does. We are one of over 70 central appraisal districts. There's one in each county in the state of Texas. And the one for Harris County is, of course, us. And our primary role, or the primary role of appraisal districts, is to appraise and value all county property, whether it's residential, commercial, could be agricultural or industrial property, as well as something called business personal. And appraisal districts are required to do so at 100% of market value being the amount that it would sell for to a willing buyer. And we do this annually. The other major role that CADs perform is administering exemptions. And that's where we're going to concentrate our conversation today. Also, we certify the appraisal rolls each year, and that's something that is done in order to allow those taxing jurisdictions. Those are the folks that you pay the taxes to, such as your school districts, your city, some of those special districts like MUDs. And then the other thing that we do, we're designed to keep the system fair. So we are the single source for property valuations in the county, in each of the counties. The state decided a while back, back in the 70s, that this was a better system than having each and every taxing jurisdiction do their own appraisal, and you would get several different bills, several different values, and so that part is centralized, and we provide that information to the taxing jurisdictions. So the district is also overseen by a chief appraiser. He's you hear the term chief appraiser, you'll see his name that on a lot of the documents that you may get from the appraisal district. He's kind of like our CEO, and we're also governed by a 9-member administrative board that is elected, 3 of which are publicly elected. And let's see our next one. We're going to talk about exemptions. I want to go into that now. So when you listen to talk about exemptions, keep in mind that the reason we're discussing this is because that may affect in terms of how you're dealing with inheriting the property, going through probate, some of those issues. Exemptions are going to be something in there that you kind of want to have an understanding about as you go through this process again. So what are they? They're designed to save the taxpayer, the property owner, money, and they can because they can reduce the amount of taxes they pay through basically as a discount based on that property owner status. And we're going to talk about that a little bit. And it's important to remember too that these exemptions are, of course, used in reducing your property tax bill before they are mailed out by the tax office. So this is just an annual value notice. If you already own property, you're probably familiar with this. This is the annual value notice that we send out usually in April, and it's sent to all property owners. Uh, and it will show what the appraised value is and what the market value is on that property. So maybe you're handling the final affairs of someone, and this comes in the mail as something you want to be able to recognize. So the two important things to note on that annual value notice in terms of how they can affect you monetarily is, of course, the appraised value and the market value. The market value is what HCAD determines each year. That's the value at which the property is going to sell to or would sell to a willing buyer on the open market. How do we determine that? It's determined basically on what homes are currently selling for in that particular community. And usually it is based on similar homes. It's important to remember that the appraised value that you are paid. Now, the appraised value is that which you actually paid which you actually owe. And that's the number that they use in calculating tax bills. That's the number that the jurisdictions use in calculating your tax bill. Now, it could be the same as market value, particularly if you have no exemptions, but it may also be lower because of primarily a 10% appraisal cap for properties that have homestead exemptions. And we're going to talk about move into what those benefits of homestead exemptions are. The most common, and those of you who own homes out there who are listening, I'm sure already have hopefully, if it's your primary residence, you have a general resident homestead exemption. There's also an additional exemption for property owners over the age of 65. There's an over 55 surviving spouse, a disability exemption. There's several for disabled veterans, and there's some other service-related exemptions. Now, I mentioned all of these. These are types of exemptions that individuals can qualify for. And it's important to remember as you may be taking over a piece of property or inheritance, that those exemptions are going to be based on the qualifications of that owner, of that previous owner in this case, and not necessarily you. You would have to apply for your own exemptions once you acquire the property. So the general resident homestead simply is the one that you get as you with the property that you own and occupy. It is your primary residence. It's the place where you live, and we simply require proof of ownership for that with some documentation like a driver's license that matches the address of the property. And so the main benefits from that general resident homestead exemption, as I mentioned earlier, that appraisal increase cap. You also statutorily by state law receive a $140,000 exemption on your school taxes. What does that mean? That means that you get that $140,000 discount. That amount is taken off your property. So if your property is a $300,000 home, then you're only going to be paying taxes based on a value of $160,000. So that's important to remember. Your school taxes are typically the most expensive ones. So that's something that the person who owned that property before you, the deceased, was receiving. There may be other specific exemptions, excuse me, that are offered by various jurisdictions. It just kind of depends on where you live in Harris County and which taxing jurisdictions you fall under. Another common one is the over 65 disability exemption. These two are pretty much the same. You can only have one or the other. The homeowner may have been over 65 and received that exemption, or they may have been disabled and they would have gotten the same type of exemption and the benefits that are offered for that. Those benefits include they get a school tax ceiling. In other words, when they turn 65 or they receive that disability, if they're granted that disability exemption, they their school taxes freeze at whatever the amount was for that previous year, for that year. So they would never, their school taxes would never go up. Could they go down? Yes, they could go down if the value of the property goes down, but they'll never go up unless they do something like that increases the value of the property substantially, like add additional square footage. You build a new room, you build a swimming pool, or you add a tennis court, or in this day and age, a pickleball court in the backyard. Then you are adding to that value. And then it would be recalculated before it resets again. You're also, of course, you will also have the benefits that come with the general resident homestead, and you're eligible for tax deferrals and to pay taxes in installments without penalties. That is something that someone with that over 65 or disability exemption also gets. Again, there may be other exemptions that may be granted by individual jurisdictions. Again, it depends on where you live in the state. The over 55 surviving spouse exemption, here's another one that if you were already receiving the over 65 as a couple because your spouse had reached the age of 65, say he passes away, then of course that ownership is going to change into your name typically. But as long as you're 55 and over, you wouldn't lose that. You won't lose that over 65 exemption or the benefits and discounts that you as a homeowner have been receiving prior to your spouse's death. Again, and of course, the school tax ceiling continues, and you can continue with paying continue with tax deferral, or you can pay taxes in installments with no penalties. Now, I wanted to talk a little bit about the homestead exemption, the heirship exemption. Before I do that, though, however, I wanted to make sure that you recognize some of the common exemptions that a person who, the heir who left the property may have had, typically would have had on the property. Those belong to that person, not to you. So once the property is deeded over to you, if you meet these qualifications, you need to apply for that again. You also want to make sure that you're aware of those types of exemptions and what property taxes might be as you go through probate. Now, I wanted to talk to you a little bit about this one because some of you may be moving into a property that is heir property. In other words, it's not been deeded to a single person. It belongs to siblings, for instance, is the best example. Typically, you by being heir property, it means you only own a percentage of it. If you've got four, say there are three other siblings, there are four of you, then you basically have a 25% ownership in the property. In the past, if this exception was made for folks that, if you lived in the property and you wanted to apply for those exemptions, then you were only able to receive 25%, 25% of that exemption because you did not have full title to the property. However, if it's heir property and there are certain steps that you can follow as an heir in order to get 100% of the exemptions that the property you may be entitled. You would be entitled to 100% of them if certain steps are followed. And it's important for folks to know this because in a lot of cases, those other three siblings, they may be all living in property and they have their own exemptions and they're taking advantage of those. However, you aren't able to because you don't own 100%. There's a process that you can follow and apply for an HCAD that allows you to receive that 100% exemption without affecting the ownership rights of any of the other siblings. So if you are interested in that or at some point need to apply for that, just know that it is on our exemptions application. Section 3, where you are going to be asked several questions, one of which is this the property for which this application submitted an heir property? If you check yes, it'll also ask if other heir property owners occupy the property. Again, you would check yes. So there's some important questions that you would need to answer, and then provide some additional information, which is listed on the application, such as an affidavit establishing your ownership interest. We would need a death certificate for the previous property owner, a copy of the property's most recent utility bill. Why do we ask for that? Because we have to make sure that the property is actually being lived in, occupied. And then any type of citations of any court records that you can provide that relate to your ownership of the property. These are some steps that you can follow in order to receive that additional discount as the property owner, as the person living in that home. So it's very important that you kind of remember that, and that in terms of helping you reduce property taxes going forward. I mentioned that there were some veterans exemptions, and of course, if you are a veteran, there want to be sure veterans may have that total VA or disabled veterans surviving spouse exemption, disabled veterans exemption, or surviving spouse or veterans disability, and also the veteran survivors exemption, which I believe is a fairly new one. But these are things that you can contact HCAT about if you have any questions. And again, these are exemptions that a deceased person may have had on the property, your deceased relative or whomever you're inheriting the property from may have had on the property, that you want to be aware of and make sure that you check, because one of the things that's important to remember is that if someone passes in January, February, those exemptions are going to remain on the property for that full year. But starting January the 1st of the next year, then you're no longer eligible for those exemptions. The new owner is not, because they have not been applied and approved for those. So those exemptions will go away. And if at that point, so keep that in mind. And I leave this in here only because of some of you might be interested in buying a home. If you're moving into the home and the home has not had previous exemptions, you can apply for something called the immediate resident homestead exemption, which gives you a prorated discount based or exemption based on the date that you moved in. So if you moved in March, then you will get from the date you moved in 10 months worth of prorated exemptions. However, if the home was previously owned and occupied and already receiving exemptions, remember for that first year, you are going to continue to get the exemptions of that person. They are going to last till the next January the 1st. And then, of course, it's when you would need to apply for any exemptions that you are eligible for. You want to make sure that you do that as soon as possible. Quickly, how do you apply for the exemptions? There are paper forms that you can send in. There are online forms. There's a mobile app that you can go out and get an HCAT mobile app, or you can email your information. A lot of that information is already included on our website. We want to make sure that you send in everything that you're asked when you send at once, so that there are no processing delay times. And also, if you're still a little bit unsure of what to do, there's a how-to video on our website that you can use that actually walks you through the process of applying for that exemption. There are also other helpful information and videos on our website that as you come into that property ownership, you may find very useful. Also, just know that anytime you file for exemption in Texas, it is absolutely free. You simply need to fill out those forms with HCAT. You may, so if you get anything in the mail offering to do that for a fee, know that you don't have to pay a fee. That exemption applications and filing for those exemptions are absolutely free. One other thing I want to show you is something that maybe in the course of being engaged in trying to rectify all the heirship and property inheritance issues. One thing that we do each year here at HCAD is to send out a little postcard, black and white postcard that lists the exemptions for that particular property owner. That comes usually in mid-December to early January, and it lists the exemptions that are currently on the property. If there has been a change in ownership, those exemptions on there may not necessarily be applicable going forward. So this is your opportunity to notify HCAD that, hey, the situation has changed. There is no, that person no longer lives here, and you can apply for your exemption. So this kind of serves as a yearly reminder for folks in terms of, are their exemptions correct on the property? And it's important to know that because eventually that information will come to HCAD's attention if the property owner has passed away, or there's a new resident, and you don't want to risk being penalized or having to pay that any back taxes because you were still paying the taxes that someone else was eligible for. So just keep that in mind as well. And again, this usually hits the mail in late December, early January to homeowners. This is what our website looks like at www.hcad.org. I mentioned to you that most of the forms that you might want to fill out are available. You can also make an appointment with us if you want to come out to the district, and then that's where you can find a lot of helpful videos and other helpful and important information. So feel free to go out there at any time. And this is our contact information. We are located out on the Northwest Freeway at the Hollister Tidwell exit. General phone number, again, our website, and how you can contact us online as well. I appreciate you guys listening to my presentation. I hope that there are a few bells that rang. And again, we will be around in the chat, my colleague Donna and myself. And now I'm going to turn it over to Shay, who's going to talk a little bit about the property tax collection and payment side of this. Thank you very much. And we'll see you later.
Thank you, Ms. Mabel.
You're welcome.
Shay,
I am here. Give me 1 second while I bring up the screen. Make sure that is correct. Can everyone see my presentation okay?
Yep, it just loaded, yes.
Beautiful. All righty, let me get everything together. Get my ducks in a row. Bear with me. Alrighty. Hello, everyone. My name is Shay Pinkowski. Once more, I am with the Office of Annette Ramirez with the Harris County Tax Assessor Collector's Office. And I'm going to speak a little bit about property taxes, what we do here at the tax office, and how we can, make sure that everyone is aware of what might be due whenever, you begin to inherit that property. So we did elect a new tax assessor last year, Miss Annette Ramirez. She is a wealth of knowledge and she has a lot of great ideas. So lots of changes happening. You might have heard about our new website. Things are consistently changing and change is good. But just a brief little introduction there. The Harris County Tax Office does more than just property taxes. We are also the office that you would go to for assistance with your license plates, vehicle registration, as well as when you're registering to vote. And just so everyone is aware, early March, we are going to have an election coming up, so just make sure that you're registered to vote if you plan on doing so. So as a brief overview, our office collects and maintains more than 1.7 million tax accounts and collect over $8 billion in property taxes. That is because we are not the sole recipient of these property taxes. We collect on behalf of multiple jurisdictions, including some schools, water utility districts, emergency services districts, and things of the like, in addition to the taxes collected for Harris County. So you'll see on your bill a bit more detail of what that looks like. But just so you know, whenever you're paying Annette Ramirez for property taxes, we are distributing those fees and those taxes to the necessary jurisdictions. There have been quite a lot of property tax changes the past couple of years, including increases for your school exemption that Ms. Mabel covered really beautifully earlier, along with the general, for example, the general homestead, as well as the over 65 and disabled homestead exemption increase, in addition to some changes involving those surviving spouse and veterans, surviving spouse of veterans. Whose death was due to a service-connected condition. So there have been quite a few changes going on, and all of them have been pretty good and positive so far. A lot of folks are seeing a lower tax bill because of these exemptions. So, you know, don't be too shocked if you see that your bill is lower than you anticipated it to be this year. So property tax bills are calculated using the value determined by the appraisal district, as Ms. Mabel mentioned earlier. But with that taxable value, the exemptions get subtracted from your taxable value and then multiplied by the tax rate. Every jurisdiction that we collect for and every other jurisdiction out there determines their own tax rates year by year. So it changes every year. And using that tax rate, they determine how much your tax is going to be owed in the amount of, and that's when we have a calculated tax bill ready for you. So that tax bill, it takes a couple of steps to get finalized and to get everything together, but that is how those are calculated. This is probably what you're used to seeing whenever you get your statement in the mail, unless you go through a mortgage company, in which case they're used to seeing this type of thing. But your tax bill looks like this, with at the bottom is a perforated third of the page, which can be used as a coupon in order to pay your property taxes by mail, or if you're coming into a branch office to make your payment in person, they're able to scan that line of barcode there in order to bring up your property, and it helps minimize errors when it comes to typos and typographical errors and things of that nature. So it's good to have this information with you whenever you're making your payments. But just so you're used to seeing what this looks like, or if you've inherited a property that you have never owned a property before, this is what you would expect to see on your property tax bill. So just so you have an idea of what that looks like. Miss Mabel covered this really well, so I'm just going to kind of breeze over it. But just visually, you can see what a difference it makes to have a homestead exemption and then to have a homestead and an over 65 or a homestead and a disabled homeowner's exemption on the property. So just a little visual representation there for you so you can see what a difference that makes and why it's so important to make sure that you are applying for any exemptions that you are qualified for in order to assist you with reducing your taxes. Tax limitations. Ms. Mabel spoke about this earlier too. So a lot of what I'm saying is a bit of a repeat only because we are the office that collects the property taxes. So we're the office that bills for it. But the appraisal district office, as she mentioned before, is the office that determines eligibility for these exemptions, along with getting us the information necessary to be able to provide you with that bill with the correct amount on it. Taxing limitations are also often called a tax ceiling or a tax freeze. And what they do is they limit the increase of taxes for your school and some other jurisdictions to cap the amount that the taxes are able to be collected on for that specific jurisdiction. This applies to homesteads of property owners who are disabled or over the age of 65 and have those exemptions applied to their account. But this is what you would see on your school tax where the math wouldn't quite make sense. So you would see your taxable value, you would see the tax rate, but then whenever you're looking at how much you actually owe for the property taxes, if you have a property tax ceiling on that property, it gets reduced. So it won't go past what the amount of that ceiling is. So that's kind of why it's important to notate on here that if you're seeing something on here and you've inherited a property from someone over the age of 65 or disabled, and you are aware that the following year, as Ms. Mabel said, that tax ceiling is no longer going to be applicable towards you, as you are not the owner who had those exemptions applied to their person as the owner of that property. Tax deferrals. A lot of folks over the age of 65 or who have a disabled exemption on their property, or even those who are disabled veterans, use a tax deferral as a form of protection. So when you're over the age of 65 and have that homestead and over the age of 65 exemption or disabled homeowner exemption or disabled veterans exemption, you're able to apply for that deferral. And the reason I bring it up in my presentation is the tax deferral protects the person who is over the age of 65 or disabled and their property while they are living in that property. Once the tax deferral is no longer applicable, meaning that that person has either passed away, they've transferred the property onto someone else, that deferral will come off. And once that deferral amount is sent to you, you would receive some form of a letter stating that the tax deferrals are coming off of this property as of this date. You have 181 days to pay for the property taxes on the deferral rate. Now, typically, property taxes incur penalty and interest monthly, and it begins at 7% and it increases by 1% penalty and 1% interest per month. So as you can kind of tell, those property taxes, penalty and interest fees can go up really rapidly, especially since it's kind of building on top of each other. And for the folks who are over the age of 65 or disabled, they may have difficulty in paying those taxes. So a tax deferral is a really great tool to ensure that the property stays in their ownership, that they are able to continue to live in that property. But that is because instead of collecting regular penalty and interest, these properties are collected at a 5% interest per year. So it is a very large reduction to the penalty and interest that typically would be assessed to a property. And that 5% interest is the deferral amount. That is what they would have to pay, at the end of their ownership. And there's no foreclosure or litigation that can be put onto property tax deferred accounts. So, like I said, it's a protection. It helps them keep their home, but it is something that either you, as you're planning your estate, or the new owners of a property would want to be aware of if there is a tax deferral on the account, and if there is a tax deferral on the account, then how much is owed, and when will that be due by. So it's always really important to make sure that you're asking those important questions whenever that new property ownership kicks in. Quarterly payment plans. These are the installment payment plans that Ms. Mabel mentioned earlier, where you would not pay with any penalty and interest. And this is for our folks who have who are homeowners and live and reside in their property and have the exemption for over 65, disabled homeowners or disabled veterans or their surviving spouse. And this is paid quarterly. You would split the total amount of your levy and you would split it into 4 equal payments, with the first being due at the end of January as usual, the second being due at the end of March, the third being due at the end of May, and the final payment being due at the end of July. So just so that everyone is aware, this is something that's available once more for our over 65 and disabled homeowners or disabled veterans and their surviving spouses. So just to be aware of what is available to you, that is quite a help to a lot of our folks here. In addition to the exemption or the options that I've provided to you before, we also offer installment payment agreements. Now, installment payment agreements and quarterly payments are different because when you have a payment plan, then you are still paying penalty and interest on these accounts. And it can be done over a length of 12, 24, or 36 months. So this is something that would be helpful to those who are coming into property or becoming owners of property, or even just trying to make sure that the property taxes remain paid as you're going through the probate process. These are available to anyone so long as the account is not deferred, and it helps you in avoiding collection efforts, foreclosure actions, and can be a really handy tool for those who are trying to make those payments without, having the ability to depend on those deferrals or exemptions. Um, there are two different types. One is which is a homestead payment agreement. The other is a regular payment installment agreement. And for homesteads, the really big difference is that you accrue penalty and interest at a 1% interest per month with the initial penalty of the month in which you create that agreement. So in February, that would be a 7% penalty and interest, and then that interest accruing additionally in a 1% interest per month. Versus the other forms of payment agreements where you would pay regular penalty and interest, as I mentioned before, that does incur quite rapidly. It starts at 7% in February, with 9% in March, 11% in April, and it continues to accrue with time. These are for current and prior year taxes. So if you have taxes that are owing for multiple years and you need to be able to pay off these multiple years of, let's say, for instance, the deferral has come off of the property, it's now showing full penalty and interest, and you're hit with that bill. This is very helpful for being able to have a structured plan and avoid that additional litigation or attorney's fees before the attorneys begin to start collections on these properties. But this is where that kind of comes in handy, is to be able to do that process and have those payment plans set up and to protect you from that further litigation and attorney's fees. We have quite a few different payment options available. We have a website online in which you're able to make your payments with a card or an e-check. We are able to also mail in your payment with a check card or a cashier's check or a money order. In addition to making a payment by phone with a card or in person at one of our branch offices, we have about 15 of them, and you can pay with either card, cash, check, or with a credit card. So just for your own reference, there is an additional fee for credit card payments of 2.4%, along with e-check payments online being a 50-cent fee. Cash is only accepted at our branches. Please do not send us cash in the mail, just because we have seen quite a few pieces of mail getting lost, and I wouldn't wish that upon anyone. So just make sure that you're selecting the right payment method for you, and I'm happy to answer questions about that in a minute. We are here to help. If you have any questions regarding property, if the situation is completely new and foreign to you, please give us a call so that we'll be able to assist you. And our contact information is listed here at the end of the slideshow. But if you have any further questions, please feel free to put them in the chat or, give us a call at any of these contact methods here. And with that, I believe I'm going to turn it over to Miss Mabel.
All righty. Shay, since we have you on last, you can answer this question that popped up in the chat. How does the tax office know when the home with a deferral is still living?
So typically what we will receive is from the appraisal district. So all of the information that we collect taxes based off of is based off of the information provided to us by the Harris Central Appraisal District. And what will happen is either, my goodness gracious, ownership change, like a deed, will go through the system with the county clerks, or they'll receive a death certificate for that person, and that information does get filed and it gets processed in their way. The appraisal district then gets that information from the courts, and whenever they receive that information from the courts, they remove the exemptions for that property. Now, they'll also send us a notice through our automated system or through our, the system that calculates for our properties, stating that a deferral is ending. And from that date of the deferral ending begins that 181-day timeline in which you have that opportunity to pay with the deferred amount versus the total penalty and interest amount as normally would be calculated.
Okay. All right. I'm going to go back through the questions in my chat as well as some of the questions that were emailed in the beginning. So, Miss Lisa, this is for you. I'm just going to ask if you can explain what a quit claim deed is quit, Q-U-I-T, claim deed is, and how it actually works. without getting into the real specifics of this question, because this is real specific between siblings and.
And if you want to email that to me later, you're welcome to do it.
Okay, yeah, because I don't want all your, that's a lot of detail that you would definitely need more information about.
If
A
any of
little,
you have questions, Miss Nia always knows how to get in touch with me. I don't want you putting your personal business out there, especially because this is on YouTube and you don't want the whole world to have access to your private business.
yeah.
So, a quit claim deed is a very bad deed to use. You should never use one. It basically does not transfer anything. Without getting into all the details, and I know that AMOS regularly has presentations about deeds and deed fraud. I recommend those, or you could go on YouTube and watch it. But quit claim deed doesn't really give you any legal right. I could make a quit claim deed on Shay's house and transfer it to Nia. It wouldn't mean a thing.
And for anybody who's interested in buying properties that's got a quit claim deed on it, I would definitely make sure that you go through a title company that actually researches ownership. So please, please, please do that as well.
You know, I was going to say don't buy it if there's a quit claim. It is not a guarantee that you're getting anything. But yeah, please always go through a title company so you know that what you're getting is correct.
Okay. What is the petition for adverse possession and how do you get one?
A petition for adverse possession is the name. So if you meet all of the requirements, and there's a long list of legal requirements for this, but say you've been living on property for 15 years, everybody knows it's your property, and you meet all the other legal requirements, what you do is file a petition for adverse possession. Normally, I would recommend you going through an attorney. I do not have a copy of that petition, but if you go to a law library, they can probably help you find it. Harris County Law Library, I should have them on our resources. They are amazing, and they can help you find that. But a petition in general is what you file when you're starting any type of lawsuit.
Okay. Okay, so Ms. Donna put the email address and the website for the appraisal district's information in the chat if you guys need to reach out to them. What happens if you can't find one of your heirs, one of the heirs for a property? You're on mute, Miss Lisa.
Sorry about that. I thought you were going to ask Miss Donna a question. If you cannot find an heir, there are procedures that the judge makes you go through. So this is I don't know enough about what it is that they're trying to find an heir for, but in general, if you have some type of court proceeding involving property, there is a neutral party who is an attorney who is appointed to track everybody down. If they cannot find somebody, if that person's been missing, they will post something either at the courthouse or in a legal newspaper that will be legally sufficient notice for that heir.
I know that there was recently a change in laws or in a law or the process for notifying other heirs when there are multiple heirs and ownership takes place or transitions or something like that, that how they're supposed to now notify all of the other heirs. I thought I recall hearing something about that, how they did it, because like in this question, the mutament of title was processed and one of the heirs and the others didn't know about it. So I think now they've recently changed that how heirs are supposed to be notified.
I need to look that up and I will do so. I will get that answer to Miss Nia and I'll make sure to add it when I do the next time I do this presentation, because there is something about notifying heirs. I think it's through the deed offices at the county clerk's office, but I can't recall the exact procedure.
I'm gonna look that up too while you guys are talking, just to see if I can find it.
Because I know I heard about it recently as well.
So can someone do a muniment of title for a property for your own self?
You may be able to. This is a brand new Texas case that the judge decided last year. So it may not be widely known yet. I would recommend talking to an attorney first. Go to something like if you're in Harris County, Legal Line, where you can talk to an attorney for free, because you want to make sure that you can do it. If you file something incorrectly with the probate courts, you might lose all of those court fees. And I don't want anybody to lose $300 or $400. So, and oh, and just to clear something up, court personnel, so clerks, court quarters, sync coordinators, people like that are not allowed to answer any legal questions. I know people get really frustrated with that, but it is a law that they cannot answer any legal questions. That's why you need to talk to an attorney in the area.
Mm-hmm. What happens to those houses that are built by like a housing program, like Houston Housing or something like that, and then there's like a forgiveness period. So say for instance, I get my house renovated under one of those programs, and I pass away, but that period is not up. What happens to the house in that regards?
I don't know the answer to that specific question, but I do know that if you qualify for one of those programs to get your home rebuilt, they require you to have a will or a transfer on death deed. So you have to prove that the house is going, I think it's 20 years, but I know that you have to prove that the house is staying within the family for a long period of time.
So nobody can actually just go out and just sell it just
No.
because
Yeah, because
there's a lien that
when
they
I was
put
at
on.
Earl Carl, we would get quite a lot of people who would come to us because the county or the state would not approve them for the rebuild until they proved that they had a will so that the house would stay in the family.
Okay. And someone's asking about the loan being forgiven. Generally, they do file like a release of lien on that property. But if you're looking for a copy of that letter, I think there's a process you have to go through to prove that you are who you are, being one of the heirs, before they'll actually even talk to you or give you anything related to that letter or being forgiven or anything like that. So they won't just give that to you or, make it public record like that.
That's correct. It's one thing, another thing that can be frustrated, but if you inherit, say you inherited the house from a family member, you have to prove that they cannot legally talk to you until there are steps in place to prove that you are who you are and that you're legally entitled to the house. It's the same if you inherit a house with a mortgage company cannot legally talk to you till there's some proof in place that you're who you are.
Same thing with reverse mortgage, with
Correct.
HELOC, with everything.
Any kind of house loan.
Mm-hmm. Is probate required to transfer deed from a late family member?
Depending on the circumstance, you can use an affidavit of heirship, and that does not go through the courts. You just have to have the correct paperwork done. Read the instructions very carefully. It's not as straightforward as you would think.
Can anyone petition for probate?
If you are an interested party, yes. Interested party could be a relative, someone who legally inherits from that person. A creditor can also petition for probate. So if an estate's just sitting there and they owe you some money, you can petition the court for probate so that you get paid back.
Through an attorney?
Through an attorney. You have to have an attorney. Thank you.
What is it? Okay, so yeah, so if you're asking to petition for probate, you have to contact an attorney to do that. You wouldn't be able to do it on your own. Can it be completed in a day? No. No,
No,
no, ma'am.
no, ma'am. It's a very, even if everything is straightforward and clear, our courts are so busy. They just opened a fifth probate court in Harris County, I think 2 years ago, and we already don't have enough courts to handle all the cases. It can be 6 months, it can be longer.
Okay, those are all the questions there. Let me go back to my email. Um, oh, oh, wow. Okay, so what's the probate procedure when a surviving spouse is the third wife?
That's really complicated. I would need to sit down with that surviving spouse and get a whole lot of information to answer it. In general, the surviving spouse, who's the third wife, could use a small estate affidavit, but you would need to know the marital history if any of the prior spouses had some kind of interest in the home or the other property. So that's not something I can answer just off the top of my head.
Do they have court-appointed attorneys for probate when you can't afford the court costs?
No, ma'am. There is in Harris County now, and he's fabulous. There is a probate administrator, and I know he is there to save property when no one in the family can go through with the process. I
It's
don't know.
Brandon Cofield.
Yeah, Brandon Cofield. He's fabulous. He does a lot of public education. I don't know the full process for that, but in general, the only time you get a court-appointed attorney is if you are subject to going to jail.
Okay. Do you even probate a small? What about cars? If there
There,
wasn't a will and it's just property, like the real property and cars, how do you switch cars over?
there is a form you can get on the DMV website where you can switch a car from the deceased person to whoever is inheriting it. So you don't have to go to court. You can use that form. I apologize. I don't know the number off the top of my head, but if you can do a search for Texas transfer car from deceased.
Okay, that's sister. Determination of property type. Okay, I'm not understanding. There's a motion for determination that certain real property is not part of an estate.
I have not
Don't.
heard of that.
But yeah, that's all that said there. There wasn't an actual question.
Yeah,
Okay.
I would need to know more about the case.
Okay. If your ex-husband has, okay, we're probably getting into a lot of detail here.
Yeah.
Um, I'm trying to read them and then give you wording that's kind of general as to not leave out something here. We make monthly payments. As part of a divorce decree, when you have to pay off a previous spouse, which means that they still have some ownership interest in it until it's paid off, and there are no existing liens. Can you? Okay, that gets more complicated there.
That's a family law question. You need to talk to a family law attorney about that. I am not.
Okay, so majority of these other ones are stuff that you guys have already answered. What exactly causes a cloudy title?
It can be if there's a lien on your property. For example, you owe the IRS, they place liens on your property. It can be, someone who does repairs on your house will often put a lien on your property if they're not paid right away. Um, Other cloudy title would be, for instance, you transferred a house and you didn't use the full legal description in the deed. Then you would have a cloudy title. It means that your ownership isn't 100% clear. It isn't 100% clear who owns that house.
Again, make sure you go through a title company.
Please.
Purchase anything that's got any kind of title, any kind of liens or anything like that. Because if you buy property that's got all of that, you inherit every problem that comes right along with that.
That is correct. Please don't try to cut corners because it'll end up being a whole lot more expensive in the end.
Which takes me back to Shay. And I like to reiterate and make sure that I go over this question at every presentation. If someone has had deferred property taxes, and this person has now passed away, if I pay the property taxes that have been owed for the last 5 years, am I entitled to ownership in that property?
No. So paying property taxes does not transfer ownership. You do not just get ownership of a property when it's not legally yours. You do have to go through that process. It does have to go through probate, but paying off property taxes for someone is a really nice gesture, but it's not very helpful to you if you're trying to claim that property.
Mm-hmm. So
I get this question all the time. You cannot gain ownership of a house by paying their property taxes. That's just a really nice gift to the person living there.
I just want to make that clear for those folks that show up for those lunches at some hotel where somebody's giving away free gift certificates so that you could buy tax lien properties and things like that. It's not valid for Texas. So just so you're aware. Um, let's see. I think those are all the questions that I had in here. Are there any other questions that anybody has that want to unmute themselves and ask directly? As I'm going through, I wanted to make sure that I didn't skip over anything. I know there were a couple of those questions that I did skip because they were very specific to your personal situation that's going to require more information before a question can be actually answered thoroughly
So,
without crossing the line of giving legal advice.
so, Nia, I just wanted to make sure that there's a point in our presentation where we needed to make clear the difference between exemptions and deferrals. You think we're pretty much covered there?
Go ahead, reiterate it again, just to
Okay.
everybody to make sure.
So we get this a lot from a lot of people who think that, well, I don't want to get that over 65 exemption because my kids will have to pay that back. Uh, that's not the exemption. The exemption is free and clear for that person who qualified. If, however, they also have a tax deferral, that means any taxes that they may have owed, they have now deferred or postponed. It's those deferred taxes that will come due following within 180 days of that deceased person's death. So anytime you may hear someone saying, I don't want that exemption. Please know the exemption is theirs free and clear. It's the tax deferral that they need to make sure that they want to tell a family member about, so that may be an heir, so they'll be aware that there's going to be expense involved upon their once they're deceased.
And how far back,
Or
Shay,
even
would they
before
look for?
then.
Or even right. Go ahead,
Oh,
Shay.
no, I'm sorry. Even before, you're coming to that point in your life, if you're making your estate plans or you're over the age of 65 and you would like to defer your property taxes because, you're on a fixed income, or, you might forget, or, bad things happen all the time, good things happen all the time. You might just forget to pay your taxes one year. It's a great protection and it's a great tool to have for those folks over the age of 65. But just make sure that everyone is aware once you have it, if you have in mind who your heirs are going to be, the sooner they know about it, the sooner they can start preparing for that. So if you're over the age of 65, you would like to defer your taxes and you tell your only child, hey, I'm deferring my taxes starting this year. This is how much the bill is. It incurs a 5% interest per year. If you want to start paying it now, by all means, go ahead and start paying it now. There's absolutely nothing wrong with making plans ahead of, getting that really big bill at the end of the line. It's better to pay it little off, well, to me, of course. I would prefer to pay off small amounts over time than to pay one huge chunk at the end, or worse, to risk having that additional penalty and interest that would normally accrue for a property than, to be able to just have the small amounts that your person would have normally paid.
Correct.
It's better to just be aware of it ahead of time.
Yeah, because after that 180 days, and if I'm not mistaken, all the penalties and the interest that would have been on it up to that point becomes due on top of the actual tax bill, correct?
Yes, and it's
If
in
it's
that
after the
moment.
180
So,
days.
yes, after the 181 days, those fees and penalties are accrued as if there was no deferral to begin with, and that goes back to when the deferral started. That's any amounts due throughout the time of that deferral. That's not like an HCAD thing where they go back and they take off exemptions. That's not the same thing. With deferrals, it's any amounts due up to that point would be due with the
So if it's
regular
been
penalty.
10 years and
If it's
you're
been
90 years old and you haven't paid taxes in 10 years, 10 years worth of property taxes are due.
right, exactly. But at least if you're deferred, then it's 10 years of property taxes at 5% per year instead of 10 years of taxes plus 7, 9, 11, 13, 14, penalty and interest fees accruing monthly. Those penalty and interest fees do really pack a punch over time and exponentially whenever you're doing it that way. So it's always best to have everyone aware of the situation so that if you know who your heirs are going to be, if you are already aware of and making those future plans and, being responsible of it, to know and let them know, hey, this is what the situation is. And if they would like to pay ahead so that they're not having to worry about it later, that's generally my recommendation.
Mm-hmm. All right. And Ms. Bates, you got your hand up. You have a question?
Yeah, I actually have a couple of questions that I put in the chat box. And I am also multitasking. I'm a teacher, so I apologize if you've already answered those questions. But
Is probate required was one of them.
yeah.
Yeah, she did go over those. You asked if
Okay.
probate was required.
Yes.
Ms. Lisa, do you want to address that again?
In general, probate is always required. You don't have access to any bank accounts or anything like that. If the only thing you need to do is transfer a house from a deceased person to somebody new, you may be able to do that through an affidavit of heirship. But if there's other things involved with the estate, you most likely need probate.
Okay, it doesn't automatically happen if it's just us that's there. No.
No.
Okay.
This is
Yeah,
something that a lot of people, it's very common to think this. You think, well, there's a will, the will left everything to me, so it's mine. It does not automatically happen. I know a lot of people that both of their parents had wills. The first parent left everything to the surviving spouse, so they didn't probate because they thought, well, everything went to mom. And then they come to me after that. I then would have to probate both wills. So even if you say you bought a house with your spouse and that spouse dies, you still need to probate that will to transfer the spouse's share to you.
Okay. Okay.
because you actually only own 50% of one property.
Correct. And it's not automatic that the other 50% goes to you. You have to go through that legal process.
Okay. Okay.
Basically, nothing is automatic. There has to be some type of process.
Mm-hmm.
Oh, because our father kind of had the same situation with his mom. They were able to, but it was a different state as well. So that's why we wanted to clarify.
I
Um,
can't answer for
yeah.
any other state, but I would be
Yeah.
surprised if it were different. In general, there has to be some type of whatever the state requires. There's always some type of legal process to transfer the home.
Okay.
Yeah.
Okay.
You may be entitled to it. Yes, it may be yours, but there's still an extra step that somebody's got to do something.
Yeah.
So it doesn't just,
So it's recognized on paper.
Yeah.
Correct.
Yeah. So that it's actually acknowledged. Yes.
You may not have to go to court. You may be able to do it through an affidavit of heirship, but there has to be some legal transfer.
And did I hear one of you guys correctly? Who completes the affidavit of heirship? Is it the person that's supposed to inherit or some other person that knows them?
It has to be signed by someone who knows them. So
Okay.
for example, an aunt, a cousin, a longtime neighbor, you cannot, if I'm using an affidavit of heirship to transfer my mother's house to me, I can't sign it. I have to have it signed by people who knew my mother, know that I'm her only child. They sign it.
And they're the ones that have to get it notarized.
Correct. And for transfer on death deeds, for affidavits of heirship, they have to be signed in front of a notary. You do not sign it and then go to a notary. The notary has to see you sign.
Okay. Okay. I mean, in general, what would be the cost associated with the transfer cost?
Which are you talking about?
For the same property.
For an affidavit
So
of
if we,
heirship?
I'm sorry, for the, gosh,
You're
for
referring
the
to the
probate,
transfer
do you
on
know?
for probate?
I don't know because I have not I have not been a private attorney for quite some time now. I can tell you that court fees at a minimum would be about 750, and it depends on a whole lot of other things. You could look to close to $1,000 with court fees. A attorneys, some attorneys charge you a lot more than what I think they should charge you. That's why I'm not in private
Oh.
practice. But I mean, it could be $5,000. I honestly don't know.
And it does require an attorney, correct?
Yes, absolutely. Now, I will say, um, apply for your local legal aid. Don't ever rule yourself out. They may be able to take your case. You never want to cut yourself out from that. If you call any of the Texas lawyer referral services, they have attorneys that take it for a lower rate. And you want to, talk to your friends, talk to your neighbors, see if they had somebody that they recommend. Even more importantly, see if they have somebody they don't recommend.
Okay.
And
I
the
see, I live in,
and those resources that she was just talking about, those legal service and Texas Lawyer Referral Service, will be on the email that I send out to you too.
oh, thank you so much.
Where is
We
the
live
property?
in Washington, DC, but
Oh,
the
you need an
properties
attorney in Washington, D.C.
But the property's here in Texas.
the properties in Wichita Falls, Texas.
Okay, you need an attorney who practices in Wichita Falls.
Okay. Okay. I would have figured.
I'm going to put this in the chat and I'll make sure that Nia has it to put. There is a statewide referral service that you can use to find Texas attorneys. It's going to take me a minute to find it, but I will get that.
Okay.
As well. Okay, yeah, I do remember you going over these. Number two, if so, what is the process to expedite or comply? You went over that. If probate is not required, what is the process? Oh, wait, what are the costs associated with transfer entity? We just talked about that. Do we need an attorney? We just talked about that. Thank you.
Okay.
You're welcome.
And
Good luck
you are
to you.
talking about a transfer after someone's passed, right? Or are you talking about a
Yes.
transfer on death deed? Okay. All right. Two different
Yeah.
things. All right.
We have the certificate of death if that has anything to do with it, but yeah.
Okay.
Thank
Do
you.
you know if there was any type of probate in Washington? Or did they live
No,
in Texas?
well, the thing is, we still have our mom's heir of state certificate. So it does say that she inherited it from her mother, but then my mom passed, so we never got that third step from my mother to me done.
You really need to talk to a lawyer, preferably one in or near Wichita Falls, because you
Okay.
want to make sure that it was transferred correctly from your grandmother to your mother as well. I mean, there's a lot of times,
Oh,
I ran into so many cases like that, people think that it's always been in the family, and there may have been a piece of paper that says it is, but it may not have gone through the legal process.
okay. Even if it includes the witness and the lawyer that actually helped.
I can't say without looking at it.
Right, right. Okay. That makes sense. Thank you.
Someone just put in the chat that if you go to the downtown law library on specific days, that someone is there also to, well, but you're in Washington, so that won't do you any good. But someone is there on specific days at the downtown, is that the Harris County Law Library?
Harris County Law Library is fabulous. And for you, Miss Bates, I believe that you can ask them questions online as well. So if you go to their website, I think there's a way that you can reach out to them. Because I do know that they will provide forms and things like that online. One thing that I didn't say that's really important, some of the law librarians are also attorneys. They cannot answer legal questions. What they can do is point you in the right direction for doing research.
Okay, and where is Harris County? I'm sorry.
Houston.
Houston. Okay.
There's
Houston,
also
Texas.
for you, there is a statewide law library that's fabulous. And I will send that to Nia so that she can put it on there. So for those of you that don't live in Harris County or don't want to go downtown, we have a state law library. I don't think a person can help you online, but it is a great website. I use it myself all the time.
Okay.
Appreciate it.
All right, you're welcome. There was another question here, Miss Lisa. Who do you talk to or how do you reopen a case? And I'm assuming this is a probate case that someone had.
It's far more complicated. You need to talk to an attorney to see what can be done, because there's a lot of complicated procedural rules about how much time a judge has power to reopen a case. So you need to talk to a lawyer who can look into the right process.
All right. Well, those are all the questions that we've got in the chat and in the email. Well, first of all, I want to thank you guys for joining us this afternoon, and we are like right at 3 o'clock. One thing I do want to say, and I say this on I try to remember to say it on all of our presentations. One of the greatest gifts that you guys can do is to be preemptive and to plan and prepare beforehand, because there is nothing like trying to have your family member to handle legal affairs and grieve at the same time. That is one of the worst situations you can kind of put your family members in. And also, you want to make sure that you give yourself time to grieve before you try to start handling all of these kinds of things, because it could be extremely stressful. For those family members that are in a rush or in a hurry to be in charge, they want to handle somebody's estate. There is a lot of work that's required to be an executor or an administrator for somebody's estate. So just kind of keep that in mind as well, whether it's going through this whole process, whether there's a will, without a will, going through getting the tax ID number, opening up bank accounts, filing tax returns, contacting all the creditors, do the accounting, submitting things to the court. It's a lot of work. It is a lot of work for an executor to have to go through this kind of thing. So, and it could be quite stressful. So just do keep that in mind.
We
For those
say this every month, and both Nia and I have personal experience with this.
yes,
Please be
indeed.
kind to the person handling the estate. They're grieving, and they also have so much work. Don't bother them about when you're going to get your inheritance, because it's a lot more complicated. I see you had the same experience I did. It's a lot more complicated, and in general, they cannot distribute any estate assets till the income taxes have been paid for the year that the person has passed. So it's a lot more complicated. They don't just have a checkbook that they're ready to write out checks for you. So be
Mm-mm.
kind. And
Mm-mm. And have the conversations with your family members, because a lot of folks too don't know about the deferred property taxes until well after somebody's
Mhm.
parent or uncle or whoever has passed on. Either they didn't know that they've deferred property taxes for years, and now it's due for somebody to actually have to pay. So you know have the conversations. If nothing else, have the conversations. For whatever reason, there are a lot of folks in a lot of communities that just do not want to even talk about it and have the conversation. But it's inevitable. Death is going to hit all of us at one point or another. It's not like you can avoid it. It's not like you can hide from it, but it's going to happen. When? Don't know. Hopefully for all of us, it's no time soon. But know that it is inevitable and it will happen, and at least start to have the conversation, at least in general, to kind of get somebody a little more comfortable, or even say, hey, we're over for Sunday dinner, we're out for that barbecue, hey, you want to sit down and watch this presentation with me? I saw so and so talking about this the other day, it was real interesting, or whatever. Kind of get them a little comfortable with having the conversation, ease them into it. Don't just show up with a will and attorney and say, hey, give me all your stuff or write it all down or whatever, because even that could be a little stressful on some people too. So, but yeah, so at least have the conversation, allow yourself some grace, give your time to grieve, and try to do as much as you can in advance of making sure that you don't run into these kinds of title issues if you want to make sure that your heirs receive the property that you worked hard for. You don't want to work all your life for your assets only for it to be tied up in court and for nobody to actually get it, because you can't take it with you anyway. So make the plans, have the conversation. With that being said, thank y'all very much. We do appreciate you all for coming back or even joining us for the first time for this presentation. As Ms. Lisa mentioned, our office will be having a transfer on death deed clinic that's going to be coming up on March the 11th. And I'll be sending, well, the first part will be on March the 11th and then March the 21st. And I'll have that flyer, that information. You will have the opportunity to have a TOD reviewed by licensed attorneys and notarized, and also maybe the opportunity to have it filed with for you in the county where your property is actually located as well. So that's a service that we're going to be offering. So join us for that. Next thing that we've got that's coming up Next week, we've got our evictions presentation. So someone's facing eviction that's a renter, and they want to know what their rights are and what that process is like. We have that presentation on Tuesday. On Wednesday, for homeowners, for maintaining and adding value to your property, what actually adds value, what could potentially increase your property taxes and so forth. That one is on Wednesday. And then the tax office and the appraisal district will be back on on February the 25th at 1 p.m. to go over in more detail those other exemptions. Would won't really kind of get into the protest process, but they touch on it just a little bit. But you want to come back and get more information about those property taxes. And then the foreclosure, HOA foreclosure prevention is the kickoff for our foreclosure prevention series through the A Month of Service. So that is on Thursday, the 26th. But I'll have that schedule as well sent out to you guys so that that you'll see what we've got that's planned. If there are any presentations that we are not currently offering that you all may be interested in, then please, we would love to have your feedback, not just about future classes, but also, this presentation. Was it everything that did you receive the information that you intended to receive? That kind of thing. We'd love to have your feedback about that too. And last but not least, I don't see, is she still here? Cecile, introduce our other partner with the City of Houston's Department of Neighborhoods. Have her click on real quick and introduce herself. Cecile?
Hi, Nia. Thank you. Good afternoon. My name is Cecile Carlson. I am one of the partners in A Month of Service representing the City of Houston. And thank you so much to our presenters for all this great information, like always. You guys are a wealth of knowledge, and I'm really happy that people get to ask questions and get solid and true and verified information straight from the source. And I appreciate everybody logging on and being a part of this. Let your neighbors, friends, everybody know that we're here to support everybody with information and services. And so, yeah, thank you so much for this presentation, and thank you for being here.
All right. So look for the recording, look for the resources, look for the websites to be included on the email sent out to all of you guys. And you should get that no later than tomorrow. So if you have any other questions in the meantime, again, please feel free to reach out to all of us. All of this representatives' contact information will be included on the email that goes out too. But with that being said, you all have a wonderful remainder of your afternoon. You all take care of yourselves, you stay safe, and we will see y'all next time.
Thank you, everybody.
Thank you so much,
Thank you, Miss
Nia.
Lisa.
Have a great day,
Thank you, Miss
everyone.
Mabel. Thank you, Shea. And Miss Donna, she was in the chat too.
Bye, Nia.
All right. Talk to you later. Bye-bye, Donna.